Hello, before we get started, let us first introduce ourselves. I'm Clay Gilroy-Scott.
And I'm Katie Dyers. We're both solicitors in the employment team at the city law firm Goodman Derrick. We ran a survey last summer to find out how businesses were actually using social media. Unsurprisingly, we found that 96% of businesses had a presence on at least one social media site, with Twitter, LinkedIn and Facebook being the most popular forums. Social media has really become embedded in the workplace, but are employers' policies and practices keeping up? To help you understand and address the employment law risks associated with social media use, we have created a series of podcasts to help employers.
This is part 3A, which is a closer look at the case law related to social media dismissal, and in particular the rights to privacy and to freedom of expression. Check out part 2 for an overview of the relevant law on what makes a dismissal fair. In this session, we're going to look at the Crisp and Apple case. Mr. Crisp made a number of Facebook postings about his work, which is set out on the slide. When he started at Apple, he had brand protection training, although he actually only completed 2.5 days of a 10-day course. Apple had a clear social media policy about the mention of the brand by employees. In this case, the employee's Facebook page was private and did not state that he was an Apple employee. He made a number of posts which a colleague showed to the store leader. He chose not to provide any explanations during the internal process, answering just no or no comment. He also produced evidence of other employees' Facebook postings. Apple dismissed him for bringing the company into disrepute. Did the tribunal think that this dismissal was fair or unfair?
Well, the tribunal held that this was a fair dismissal. Amongst the tribunal reasoning was that his friends would have known that he worked at Apple, and it was acknowledged that Apple placed great importance on its brand and image. They also felt that his no-comment approach during the investigations indicated that he was at least aware of some form of misconduct.
The case is interesting because it also brought up the Human Rights Act 1998, and specifically the right to respect for private and family life in relation to the right to freedom of expression. This may be limited if the purpose is the protection of the reputation or rights of others. In both cases, if there are any limits on the rights, these must be proportionate.
The tribunal's view was that the nature of Facebook and the internet generally is that comments can be very easily forwarded on. The claimant therefore had no control over his comments and should not have had any expectation of privacy. They also pointed out that this was not a case where the employer had hacked into the employee's account and thereby infringed his privacy. In this case, the information had been passed on by one of his Facebook friends. Although the right to freedom of expression had been engaged, the dismissal was proportionate because Apple had emphasised that protecting its image was a core value. The tribunal also noted the fact that the claimant had done the same thing to some of his Facebook friends during the disciplinary process, printing their postings and passing them to Apple.
Employees may not therefore have an expectation that their posts on private social media sites will actually remain private.
In an attempt to avoid such issues, we are starting to see disclaimers by employees that postings are representative of their own views. An example is on the slide. It is from the profile of Angela Gibbons, who is a director at the British Council. She clearly states, "Personal capacity tweets only here." The tweet at the bottom of the slide is her tweet in response to a tweet about Prince George. As far as we understand it, the post resulted in her suspension from work, followed by disciplinary proceedings against her, in which she was dismissed for gross misconduct. Whilst it might have been her personal view, it still potentially impacted on the reputation of the organisation, and was therefore taken very seriously by her employer. However, do bear in mind that the British Council is a taxpayer-funded charity, has a royal charter, and its patron is the Queen. Also, Prince George and his parents had met with schoolchildren in France earlier that month as part of a British Council programme. As we understand it, the employee subsequently sued the British Council for unfair and wrongful dismissal, as well as discrimination on the grounds of her Republican beliefs. We await the Employment Tribunal's decision and whether this will throw any light on whether the disclaimer wording was effective.
We've set out on the slide a summary of factors that the tribunals are looking at in considering whether an employer has been reasonable in dismissing. So, did they carry out reasonable investigation and inquiries?
How offensive or serious were the comments that they posted?
How many posts were there and how many could and did view them?
Was there a breach of policy or guidance or even a contractual term?
And has there been evidence of actual reputational damage caused?
Was there damage to the employment relationship?
What was the individual's employment record like?
Did they issue an apology, and how prompt was that?
Was there any damage to client relations?
And are there any other mitigating circumstances?
You may be interested in Part 3B, where we will go through 2 cases involving threatening social media postings. And if you have not already viewed it, watch Part 2, which took you through the unfair dismissal considerations in more detail.
Thank you for watching, but just before we go, no social media session would be complete without us sharing our social media presence with you. Please do follow us on Twitter at @EmpLawHeroes and connect with us on LinkedIn. Please also get in touch should you need any employment law assistance. We would be happy to help.
And do check out our other podcasts for more information about social media in the workplace. Bye for now.